Jackson.
So can I invite you to reflect back to Justice Thomas's question? And you said that there were two paths to getting to your result. And you mentioned Salinas is one, and I think I might have heard the other, but let me just give you the opportunity to explain what those two paths are.
Yeah, so in Salinas, I think because it's criminal liability, the court is very clearly relying on a combination of the spending clause to attach the condition and then the necessary and proper clause to enforce it, because you can't do criminal under contract. But I think in this case, because we have civil liability and it's this chain that runs down to the officers, you don't even need the necessary and proper clause. I think this is an unusually easy case because of the way that so just sort of
the chain of privity is the second.
Because the chain of privity is the second. So I think you could come at it either way. And I represent a private litigant. I don't really care which one you do, so long as you reverse, of course.
So do you view Louisiana's constitutional argument as turning on the contract analogy? I mean, do we have to sort of accept that the spending clause and spending clause legislation is subject to characterization as a contract in order to buy their argument?
I'm not sure. Maybe they can speak for themselves on that. I think the spending clause is properly understood as being the spending clause alone. I think it is consensual in nature. I think this court has been clear about that. But then the question of
but we've also been, I just want to be clear about this. I mean, we've also expressed pretty significant, in many cases, doubts about whether the contract analogy totally governs.
But yeah, and that's what I was about to say, because it doesn't get, this court has also been clear, and they're not asking to overrule any of your precedents, that Congress can invoke the necessary and proper clause to protect its spending prerogatives. I mean, look in our reply brief, we have the example of the statute that makes it a crime to arson a federally funded institution. Right? That's the use of the necessary and proper clause in conjunction with the spending clause, and which, as I understand their brief, they're saying that that's off the table. Whereas I think what we're saying is because this is officers, within the scope, it's a valid condition, and it's conduct that threatens the sort of core operation of the program, then it's just controlled by Salinas, and you don't need to break any new ground.
So how much precedent would we undo if we held that RLUIPA's individual capacity cause of action for money damages is unconstitutional? I mean, is this a big deal case or not so much?
I mean, I certainly think it's a big deal case, and we've included. I think there are these like 5 or 6 precedents from this court that I just don't see how they can square their position with. Salinas, Hess, Laudani, Dixon, Grove City College versus Bell, and Sabry. And then just above and beyond the court's cases, I mean, we traced through a history of statutes that are similar to this, running all the way back to 1789. The first Congress imposed that had a scheme for imposing individual liability on officers in working in a federally funded state prison. False Claims Act of 1863, anti-kickback provisions that started in the 1930s. Title IX, Title VI, that's Grove City College versus Bell. Title X of the Public Health Acts, EMTALA, there's whistleblower provisions, Prison Rape Elimination Act, the arson statute that we were talking about. There's another one about blocking interference to federally funded programs. So it's a long list of statutes
that could be imperiled.
Yeah, where Congress has traditionally protected federal programs, and I think in particular imposed conditions and enforced them as to people who are in this position of being in the chain of privity. They're officers, agents, employees, or subcontractors of the grantee.
Thank you.
Thank you, counsel.